Hello. One of the questions recently asked is about the difference between appeal and judicial review. And the difference is not so simple and sometimes is even huge. But again, if you need particular information about your particular case, you'll probably be better off with your own lawyer, just consulting about your particular situation. So this short video will be only about the major difference, the major distinction between the two. To make it short and quick, on appeal, a court, it might be of course a court of appeal, but sometimes when you're appealing from an administrative tribunal decision, it might be an appeal to the Court of Quebec, or again, sometimes to the Court of Appeal, or from the Court of Quebec to the Court of Appeal. So again, you see there are situations, there are differences. It might be even the federal court. So if you're not sure, consult your lawyer. But the point of appeal is that on appeal, the judges usually verify if the law was applied correctly. That's the major point. And sometimes if some blatant critical facts were not taken into account, the Court of Appeal might also correct that, or the appellate court, whichever it is, might correct that. So technically at the end it's possible that on appeal the decision is not only reversed, that it's corrected, in the sense that the appellate court would change some paragraphs or the verdict altogether, and that at the end you will have a different result on the very same litigation, the very same court case. When it comes to the judicial review, it's usually, again, there are nuances, but usually it's less strong, because the Court on Judicial Review, usually it's Superior Court of Quebec, verifies, but yeah, it can be a federal court. The court verifies if the decision, how it was made, fell within the limits of what could be reasonably decided. And even if the judges of that court are not entirely supporting the decision as it was made, as long as it was within the limits of what was reasonable, the decision will most probably stay as it was. So to revert all that, to do something about the decision of usually administrative body by way of judicial review, you'll have to show that the decision was beyond the limits of reasonable. Of course, there are situations when the standard of review is different, is correctness, but after the Supreme Court decision in Vavilov, mostly, at least presumably, we go with reasonableness. So if it's ridiculous in your eyes, it's not enough. It should be ridiculous in the sense that such a decision is not even possible under their legislative act, or such a decision is absolutely, or at least really impossible within the given facts or under the current regulations, or the reasons which are usually delivered to give you such a decision were just not based on what they should have been based upon, and so on and so on. So basically, just this flat and very, very general answer is that on appeal you have better chances to reverse, or at least to correct the decision. On judicial review, mostly the case should be preposterous. The decision should be preposterous, beyond what might be, and then the judges might interfere. But again, in reality, there are a lot of fine distinctions and a lot of nuances. So if you wish to understand it better than this very general information, then I suppose you'll need a lawyer. Thank you, and have a nice day.